Good morning, Daniel Olds here on behalf of Angela and Stephen Roberts, along with my colleague Justin Cox, and Ms. Roberts is also here virtually as well.
Good morning, Mr. Olds. Do I have anyone here on behalf of the defendant? David Benjamin Slade or April Slade?
I'm here representing pro se, my wife's and my interests. I wrote you yesterday evening, Your Honor. The reason I'm dressed in sweats, norovirus has run through our family over the past week. We have three small children, 3-year-old, 2-year-old, and a 4-month-old. And we believe this is a retaliatory eviction. And I have not had time to retain counsel and gather everything necessary. And so I'm pleading for a 2-week extension.
I wouldn't be able to do that at all. Mr. Slade, these are considered time of the essence cases, and by law, they must be set within a specific amount of time. Let me take a look at the filing. If best, I might could give you like 24 hours. But more likely, you would just have to appeal, and the appeal is what might give you the time that you need to seek counsel. But let's take a look. Mr. Olds, do you know what day the case was filed, just straight away?
It was, I believe it was September 19th. Let me double check that.
Yep, no, you're right, 19th. Let's take a look. All right.
And Your Honor, I would just point out.
Oh, don't. I'm trying to count. One.
Okay.
All right, Mr. Olds, go ahead.
I was going to say, Your Honor, a week after that was filed, Mr. Slade emailed one of my colleagues here in my law firm the draft lawsuit that he said he was going to file or have filed in Travis County District Court that was purportedly signed by an attorney against my clients, Angela and Stephen Roberts. And so I think, this notion that he wasn't able to find an attorney for this lawsuit rings a little hollow, and he was able to apparently find one to tee up a lawsuit against my clients in district court.
So, Mr. Olds, what you're saying is that the defendant has sued your clients in district court?
No. He has not sued them, but he was threatening a lawsuit. So he sent a draft lawsuit that was fully drafted against my clients.
Was it from counsel?
No. He sent that to one of my colleagues, but it was signed by apparently an attorney. Okay. I'm happy to share my screen if the court wants to see that.
Yeah, Mr. Olds, so you got a letter from a lawyer on behalf of the defendant?
My colleague got an email from Mr. Slade himself with a draft lawsuit
involved in that.
I don't know how Mr. Slade found this lawyer. I think he has the same last name.
So that's, again, I'm getting lost. Mr. Olds, you got a letter from the defendant, but the defendant sent you a letter from a lawyer that has the same last name. Is that the story?
No. My colleague at my law firm received an email from David Slade.
Okay.
That email contained an attachment of a draft lawsuit that was styled against my clients that looked like it was going to be filed in Travis County District Court. And it was purportedly signed by an attorney, I believe with the same last name, so there might be a relation to Mr. Slade. But so my point is that he seemed to be able to find an attorney to do that, but not to represent him here.
You received your colleague at your firm received a letter from the defendant, and the defendant sent a letter from a lawyer. It was a draft
an email, yes, with a draft lawsuit, yes.
All right. Mr. Slade, is that correct? Did you send a draft of a possible lawsuit?
My mother-in-law is filing a lawsuit against the plaintiffs for negligence and duty of care. When we moved in, we noted that the lighting in the back stairway, among many other things, was out. And after months and months of having the lawn care company out and assess it, we received notice, which we included with our email to the plaintiff's law firm, that they refused to repair it. And my mother-in-law slipped and fell down the back stairs and broke her foot. And that's all documented. She was over at St. David's Urgent Care B Cave shortly thereafter. And so I am, yeah. So that is.
Did a lawyer draft up a potential lawsuit?
Yes, my father.
Your father is a lawyer?
Yes, he is. He practices in Houston.
Then Mr. Slade, I'm going to deny your motion to continue. All right, Mr. Olds, what's this case about?
This case, simply put, is about Mr. Slade's failure to pay rent.
Non-payment. Okay.
And he is and my client, so I had my client on the stand if the court wants to hear her actual testimony, but
y'all, it's a non-payment matter. Give me the set of facts, and if there's a dispute, then I'll take the witnesses. But it's a non-payment.
Absolutely.
So how much monthly rent?
Absolutely. So there was a lease entered into between my clients and Mr. Slade. That lease ran from October 21st, 2024, with an expiration date of April 20th, 2025. On about April 9th, 2025, my clients provided the tenants the written notice of lease termination pursuant to the lease agreement, which requires a 30-day notice of lease termination. Sent that notice. Tenants did not vacate by May 20th, 2025, and have continued to occupy as holdover tenants since that date. Pursuant to the lease, rent is actually 3 times the normal. So the rent amount was $15,000 per month during the time of the lease. Since they're holdover tenants, it's actually now $45,000. That's beside the point because they haven't paid that amount. Beginning on or about May 20th, though, tenants did make some rent payments to my clients in the amount of $15,000 on the 20th day of the month through July 20th. But since July 20th, have not paid any rent money to my clients. They paid no money.
Okay,
On September,
Mr. Olds. Y'all sent a letter on notice to vacate in April. And that was based on a non-payment?
the
What was the
April,
notice to vacate notice about?
that was the notice of vacate. That was the lease termination letter saying we're ending the lease. We're not going to continue this lease. Please get out when the lease ends.
When did you give them the notice to vacate for the lease violation?
For the lease violation, that was September 8th, 2025. They're given a 3-day notice to vacate.
3-day, September 8th. And in that 3-day notice, what's the reason that the notice was given? What's the violation?
Sure. The letter says, would you like me to share my screen, Your Honor?
No, just, right, what does it say?
Sure. It was basically, despite the landlord's April 9th letter, you did not vacate the property by May 20th, 2025. You've occupied the property as holdover tenants, pursuant to the lease.
So if the 2 notices are because you're a holdover and you haven't made payment. I'm looking at the
Yes.
letter, September 8th, via
Yes.
U.S. mail and certified mail, 3-day notice to vacate pursuant to Texas property code. This letter is
Yes.
written on behalf of the landlords. As you're aware, you have a residential lease. The lease expired April 20th. By the letter dated April 9th, we notified you that your tenancy was going to terminate the following month. You must vacate. Despite getting that letter, you did not vacate. So 1, you're a holdover. And 2, you haven't paid the rent as required as a holdover. So when he became a holdover, the rent tripled to $45,000.
That's correct, Your
Did he attempt to pay the $15,000?
Honor. He paid the $15,000 through July, but has not paid anything since July.
Your Honor,
No payment
by
since-
and through,
So he paid July, Mr. Olds?
Well, he paid $15,000 through July 20th of this
And
year.
so rent had been being paid on the 1st of the month. Is that what the lease required?
I believe that's correct. My client can confirm that, but I believe that's correct.
So a dispute arose in April about whether or not he was a holdover. And even if there's a holdover, there's a dispute about whether it's 15 to 45,000. Was there a point at which he paid nothing toward the rent?
Yes, beginning the last payment he has made was July 20th. He has not paid any rent since then.
All right. And has a copy of the lease been provided?
Yes, Your Honor. That is, I believe,
Does the lease
exhibit.
have the terms of the holdover and the renewal rates?
It does.
Oh, do you recognize this as a copy of the lease from your client?
That looks correct, Your Honor.
Mr. Slade, is this like a copy of the lease you signed?
that is the original one through April 20th. We signed an extension through October 20th, which council has failed to mention.
Mr. Slade, we're gonna get there. I want to see y'all's lease, right?
Sure.
This lease says it's October 21st through April of 2025. This is the lease the parties entered into. Mr. Olds, were there any additional leases signed besides this one?
I'm not aware of any additional leases, Your Honor, no.
Mr. Slade, just yes or no? Did you sign any additional leases?
Yes.
Okay. Automatic renewal happens everyone, goes month to month unless you get 30 days. So it ended April 20th. And when did y'all said April 9th, you gave him the notice of non-renewal?
That's correct, Your Honor.
Told him to be out by end of May.
I believe it was May 20th. Yeah, May 20th.
So you needed to tell them by March 20th, otherwise it automatically renewed. And y'all told them April 9th, so it had automatically renewed per the lease
Um,
because you had to give, the landlord said we must notify 30 days, either one of us, and if we don't, it automatically renews. And since the landlord
Right, so
missed the
we
30-day
gave more than-
deadline,
we gave more than 30.
Mr. Olds, automatic renewal. This lease automatically renews
Right.
unless the
Oh,
landlord
I see.
or tenant
Yes.
gives notice 30 days before the expiration. So it expired April 20th. So the notice
Sure.
needed to be sent by either one of them March 20th. Your client was late, so it had already renewed by the time they sent that non-renewal.
Yes, but the 30-day notice was more than 30 days before they were told to leave.
You, Mr. Holmes, you just told me that y'all sent, your client sent a non-renewal notice April 9th. Is that correct?
It was a written notice of lease termination.
We're saying the same thing, non-renewal and termination. They sent that notice April 9th.
Yes.
So that is not 30 days before the end of the lease as required. So it had already renewed.
Yes, I understand what Your Honor is saying, but
I'm
they gave
reading
more
the
than 30 days.
lease.
Yes, but they're
Right?
given more
If
than
this
30
was
days. notice to
reversed,
vacate.
if this was reversed and the tenant had sent that notice on April 9th, your client would have been 100% correct to say, no, you've already become a holdover for a month. We've already automatically renewed. You're not a holdover, you have a whole 30 days. If you're wanting to terminate with me now, you owe me rent through the end of May and then you can terminate.
Sure. So it renews on a month-to-month basis.
It removes on a month-to-month unless landlord or tenant gives the other party notice not less than 30 days before the expiration. So it expired April 20th. One of the two parties needed to tell the other, we're not going forward with this relationship, and that had to take place by March 20th. Defendant didn't say anything. Landlord didn't say anything. And then 11 days before this lease came to an end, your client sent a letter that said, we don't want to renew. Please be out May 20th, which was an incorrect notice because they already had until April. They already had until May 20th per the automatic renewal.
But yeah.
Right? Okay. So
But legally they had to get out by May 20th. Legally they had to get out by May 20th. Yes.
So they gave written
I'm
notice.
not disputing they had to get out before May 20th. I think that's right. Yeah.
All right. So they said we don't wish to renew. And at this point, when the non-notice was sent, April 9th, tenant was current in the rent.
Yes.
Okay. And then May rolls around. Tenant pays the May.
It did pay the May.
And how much did he pay in May?
I believe it was the $15,000.
And did your client say, send him a letter, say, hey, you're short, you should be paying us 3 times that amount?
I don't believe they did for May. No.
Okay. How about in June? Did the defendant pay in June?
They paid. Yes, they paid June and July $15,000 through July 20th.
So
Rent was due the
issue arises
20th.
in August.
I'm sorry.
So in August, no payment was made at all.
No.
All right. So then we get to the September notice to vacate. As you're aware, you previously entered into the lease. That's true. The lease's primary term ended April 20th. I would say I'm looking at the notice to vacate, and I would say that I would disagree with the first assertion in this one, right? So I don't deem him as a holdover at first because the landlord gave a notice to not renew, but they were late in doing it, so he got an extra amount of time, right? But after that, landlord said, I don't want you anymore. Then it did become what would have been a holdover, except that, well, the fact that you paid doesn't change that situation. So he is a holdover at some point. It's just not as soon as you asserted it as it's put here, right? But it gets there because the notice that was sent, even if you pushed it out, only got him through the end of, at best, June. So in July, there's a holdover situation. In August, definitely a holdover situation. And so the September 8th letter is misstating of the dates, but is not incorrect in that a holdover exists. All right, but let's look at the non-payment because that's also a situation. Now, payment wanted to be 3 times the rent. So by the time we get to August, let's go back to the lease. Mr. Olds, where in the lease can I find the renewal rate or the holdover rate that triples it?
It's paragraph 22.
Okay, holdover. Yep, pretty standard. Rent for any holdover period will be 3 times the monthly rent calculated on a daily basis and immediately due and payable without any notice or demand. They don't have to advise you about it. They don't have to say, hey, don't forget, it's just it's part of the lease. There it goes. All right. And then nothing got paid in August. Nothing's been paid for September. Nothing for October.
That's correct, Your Honor.
Well, rent is due the 20th of the month.
All right.
So rent is not due. We were, once again, we signed a lease extension through October 20th. You know,
Oh, Mr. Slade,
some,
Mr.
yes.
Slade, do you have a copy of the lease extension? Because I'd love to see it.
Yeah, let me see here.
Did you submit it to?
No, I haven't had a chance to submit anything. I'd honestly, I'd been emailing with their attorneys, not only Mr. Olds
Oh,
directly.
you said you hadn't
and-
talked to an attorney, Mr. Slade.
No, I haven't. I was emailing with their attorneys. The gentleman here. No, my father's an attorney. That's really it.
Mr. Slade, can you pull it up? If so, we can let you screen share.
Yes, I'm trying to find it here. Here it is. Okay, how do I screen share?
We're going to make a limited share. Mr. Slade, I'm going to give you a warning, and I give this to everyone. When you screen share on Zoom, if you're not familiar, it will literally share the whole screen. So if you have extra tabs open or instant messages that pop in, maybe minimize all of those things so that when you choose to share your screen, it's going to show all open things on your desktop. Just FYI. I've also learned a lot about Zoom in the last 6 years.
And then, Your Honor, you're the host.
Oh,
Okay.
all right. There you go, Mr. Slade. I'm giving that back to you, Brochet.
Okay. And so now you'll just have to select.
And I would add, this was negotiated between our real estate agent and their real estate agent, and we have the text messages that say that they agreed to this, and yet they, you know, we found out really, you know, April and I signed this back in May, or whenever this was executed, and then
Just like you
they
haven't
never
shared
sent
the
us.
screen yet.
Oh, I clicked the button.
I'll try again.
Okay, there we go.
All right, so that's the lease. Show me the renewal.
No, this is the renewal.
All right, can you, yeah, there we go. All right, so this one is May 21st, 2025 through October of 2025, so a short extension. Mr. Slade, who is the DS initials to the left on number 4?
Those are mine.
And who is the AS below that?
That is my wife, April.
Where did you get this document from?
This was sent to, by their real estate agent to our real estate agent to us, signed via DocuSign.
Mr. Olds, can you confirm with your client if that is correct?
I have not seen this before, Your Honor. I'm not sure my client has signed it. I don't see anywhere that they have
That's
signed
not
it.
what I asked. Did they send it?
I'm not aware. My client's on the call.
Would you like to take a minute and ask him? Because this isn't a very specific kind of document here that directly contradicts the things that you told me. So
Angie,
if you
could
want a
you
minute
please
to
get on
confer
it?
with your client, we can, but like if they prepared and sent this to the defendant, that's an offer to renew. And if they signed it, they're stuck with it.
Sure. If I could
Really any
talk
holdover
to my
argument.
client. If I could talk to my client really quickly.
Why don't we take a short recess and we'll give you a chance to go into a private breakout room. All right, Mr. Slade,
Okay.
stop screen sharing.
Stop screen sharing?
Yeah, we can stop screen sharing. What we'll do is we'll give it a recall.
Okay.
Mr. Olds, if you need a moment, we can give you a breakout room. Otherwise, you can put yourself on mute and contact your client. Mr. Slade, please don't go anywhere. You can also put
No.
yourself back on mute. We're going to go to the next case and we're going to recall this one, okay? All right, just real quick, when we left, we were taking a look at a renewal that Mr. Slade said he had received from the plaintiffs. All right, Mr. Olds, what did you discover?
Yeah. So what happened was there was an offer to extend through October that a colleague in my law firm sent to Mr. Slade. And then he unilaterally made changes to that document that we did not agree to. And then he signed it and we never countersigned.
I have text messages. Sorry.
Mr. Slade? Mr. Olds, what changes to the offer did the defendant make?
I'm not sure. I don't have a copy of it in front of me.
Who rejected it? Who said that, hey, he made changes to it? So where can we get that info?
I spoke with my colleague and he is supposed to be sending me a copy of it and he has not sent it to me yet, but he told me that that's what happened. So apparently he scratched it out on the document. So if he could pull up that document again, I think there were some changes that he made to it before he signed it.
Mr. Slade, you know if you made any changes or alterations?
Yeah. Can I share my screen again?
Yeah.
The only change was that we noted that they would not be able to show the house while we were still living in it.
Cool. You made a change. All right. So
and there's the agreement. There's the agreement where they agreed to.
So I just got an email, Your Honor, from my colleague. So sections 14D1 and 2 are what was struck through.
All right. So Mr. Slade, you wanted to make changes and you said, hey, I've sent it over. And then did they sign it and send it back to you with those changes?
They agreed to. This is the only contact we have with them. This is their realtor. She works for Kamara Wilcoxon, I guess their head realtor, who indicated that they agreed to it to just initial and do the strike throughs. And this was a screenshot sent from our realtor.
Do you have any idea with your clients who Jessica Doskar is? Because she says, hi, David, the owner has agreed to proceed with not showing at the end of the lease. And I can see that it's dated June 16th. This would appear to be an acceptance of his alterations or his amendment.
Well, my client does work with Kamara Wilcoxon, but and so this person works with her. I suppose that's true. I don't
see how they're not in a new lease.
I don't think that this is an acceptance of the changes that he made, though.
Hi, David. The owner has agreed. Please send the lease docs with the initials. I don't see any way to not approve that as an acceptance of the offer.
So he struck through
Hi,
section
David. The owner has agreed to
14D1
proceed.
2.
Please resend.
I don't think it was ever signed. I don't think it was.
Mr. Olds, it's striking me that maybe the story is not as clear from your client's side, but right now what I've got is after I was told there was nothing, it turns out they did send from your firm an offer to renew. Defendant made changes and those changes were accepted right here by someone who appears to have agents in the ownership. So I'm not sure why we're here because they're not a holdover now. We're going to get back into non-payment. So the non-payment is going to go back to the $15,000 amount. Mr. Slade, did you offer to tender payment at $15,000?
I'd been doing that until we were notified. And here I can share this screen too. Does this automatically share? Or do I have to stop share and reshare?
You have to stop sharing.
Okay, and then I'll reshare. Again, we noted when we moved in that the backlighting didn't work.
Yeah,
it seemed to be a nominal thing.
Mr. Slade, I'm not worried about that. This is a real simple situation, right? All the other things, because it can't have been too bad. Y'all negotiated to stay longer. And here it seems like they approved it. So these are more text messages. I don't care about lighting. Here's what I got. Here's y'all, so Mr. Olds, Mr. Slade, here's the situation as I've heard it so far. The plaintiffs leased a home to the defendants. The lease came to an end. The defendants did not receive timely non-renewal. In fact, the plaintiff was late in giving them a notice of non-renewal. Even after the late notice of non-renewal, the parties then decided to negotiate, and they did. Plaintiff sent over a new lease, which defendant amended and said, I don't like your offer, I want to counter. And then plaintiff accepted the counter offer, which I take to be true through that text message just shown. That means that once defendant sent it back, they have a new lease. So it's not possible for them to be a holdover. So then we get into whether they paid the rent. I didn't see anything in the renewal that changed the amount of the rent, which means it was at $15,000. If Mr. Slade was trying to tender $15,000 correctly, and plaintiff is saying, no, you need to give me 45, I would say plaintiff is incorrect.
He hasn't paid anything. He hasn't even paid $15,000.
So Mr. Slade, you haven't paid since July, correct?
Rent was due July 20th. I did not remit payment on August 20th or September 20th. I was trying to negotiate with plaintiff. I actually initiated payment I guess the day that within 30 minutes after this was filed, and I sent
No.
plaintiff.
You can't pay late. Here's my point, Mr. Slade. Per the terms of the negotiation that you renegotiated, rent was due on the 20th, right?
Yes,
Okay, and did you pay on August 20th?
I did not.
Did you attempt to pay on August 20th?
I think no.
Okay,
On that
about
date.
September 20th.
Well, September 20th, they filed this this notice before
Yes,
then.
but you're still
this
in
eviction
possession.
notice.
The fact that they're trying to evict you doesn't mean you don't owe them rent. Did you
Actually,
pay
I know.
rent?
I actually initiated payment for all 30,000 on the 19th. I ceased that payment when this eviction proceeding began because I was told that I had now owed 45, and so I actually forwarded to their office the ACH confirmation from Frost Bank for the 30,000.
Okay.
And I would happily redo that immediately, but here we are. We paid over $165,750 in rent over this year. This comes to you because we wanted to buy the house, but we had verbal agreement similar to these text messages that we've shown you that they would let us buy the house, and then that was reneged. And so, we had a daughter. Our daughter arrived on May 16th. They knew that. They sent us a notice to vacate on May 20th. It's felt like harassment a lot of this time.
Your Honor, may I say something, please? Would that be possible? This is Angela Roberts.
Ms. Roberts, I'm going to ask Mr. Old to lead you in a line of questioning because he's your counsel and you're not prohibited from it. Mr. Old, do you want to ask questions or? Ms. Roberts, you can. You have an attorney here and typically the attorney wants to be kind of a gatekeeper for that. So I'm just making sure.
If Ms. Roberts wants to say something, I'm fine with that.
Go for it then, Ms. Roberts. Yes.
So, just the summary of events is that we've been very good to them, and they've been dishonest with us about the ability to finance, and even sent an email saying that they were trying to get a line of credit with Frost to be able to pay, and then basically sent a blackmail email to the attorneys, which I have never seen anybody say, if you don't allow us to stay and work with us, we're going to sue you, have our mother-in-law sue you. That email was sent to my attorneys to tell me, and I've never been treated that way, and we've been very good to them and have been very understanding through a lot of this. And I just want it to be over because we've bent over backwards. We even accepted them when their credit score was low, and we've been nothing but decent human beings, and I don't think we've gotten that in return, and that's all I wanted to say.
All right, Ms. Roberts, thank you. Mr. Olds, Mr. Slade, Ms. Roberts, thank you all today. As I look back at the paperwork, I find that the answer lies in the notice to vacate. I'm going to share my screen, okay? So this is the notice to vacate, which starts the process for an eviction suit like this. It is a necessary required letter. You must provide this as the landlord to the tenant. The notice must give it must be correct in the notice that it gives, right? When I read this notice, I find it to be factually incorrect. And I'm going to explain why. One of the first things you say is that the term has expired. I don't find that that's true. I find that's not true for two reasons. One, per the terms of the original lease, the landlord and the tenant both had a duty to notify at least 30 days in advance. The landlord did not do that. And since tenant did also not say anything, it automatically renewed for another month. So it's not possible for that original that holdover to be true right? Even beyond that, parties then negotiated in good faith for an extension of the renewal. Now, maybe that's because y'all were trying to buy the house and deep down, all parties thought y'all were going to make good money at the end of this. Someone's going to get a house, the landlord's going to walk away with big money, right? But I can see that the landlord sent over a new lease, a very new lease, clearly through October. And then the tenant modified that and sent it back and said, we'll accept it with these changes. And an agent for the plaintiff said, we accept. And it's not necessary for the plaintiff to sign the lease because they sent it and they agreed and they received it back. They're getting the benefit of that, right? So with that renewal, unless it changed the rent was still $15,000. So when this says that you're behind because you owed treble times, that's an incorrect statement of fact as well. For those two reasons, this notice is ineffective, and today it's going to be a judgment for the defendant. Mr. Colds, the client can absolutely appeal my decision. For this type of case, I would also set the appeal bond equal to 1 month of rent. So it would be $15,000. Certainly, I recognize that's a substantial amount of money. So if your client cannot afford that, which might very well be a thing that you don't have that much cash readily available, they may qualify for the affidavit of inability, and that would not that, the fact that you have a lawyer doesn't necessarily change some of that situation. So you both have 5 days to appeal. You can also do other things with it. All right, so that's it. All parties are excused. Thank you.
Thank you.